Hi everyone. Welcome to our PMCC 5th BrainHuddle webinar of the year. It is our pleasure to have you here with us today. Just a little bit of introduction at PMCC. We provide project management and consulting services for a wide range of sectors globally. BrainHuddle is actually one of our initiatives to provide a platform for experts of respective fields to share about topics relevant to the current situation in the market, allowing you to relate to the knowledge in real life work situations. So before we start, I would actually like to give a little bit of what we call house rules. So I would appreciate it for you if you can mute your mic and only unmute yourself unless when we say that you can. And then if you have any questions throughout the sessions, you can type in the chat box, and then we'll address them accordingly if it's necessary. Apart from muting, if you want to switch on your camera, we gladly we'll be gladly looking forward to see your face on the screen. So for today's BrainHuddle session, our topic is obviously contracts, administration, performing your obligations, and protecting your rights, which will be presented by none other than Jamie Duncan. So just a little bit of introduction of our speaker. Jamie is our Managing Director for PMCC Actors in 𝗪𝗲𝗶 and the Director of PMCC Corporation at Southeast Asia, based on construction consultancy. Amongst Jamie's role within the company is specifically relating to our topic today, which is leading the contracts and claim services, which range from pre-contract negotiations, contract administration, claims, and dispute services. Apart from this, Jamie is regularly also appointed as an independent expert in matters related to delay and quantum for projects seeking out resolution via adjudication, arbitrations, and legal proceedings. So Jamie has a vast experience spanning over 20 years in industry and has attained his RICS chartered status in 2005. That means like it's almost 20 years. So he has worked on both as employer and contracting side of the industry in various countries, namely UK, Middle East, Southeast Asia, and Australia. Working with both employer and contractor organization has given Jamie a great insight and understanding on the different approach taken by both parties, which he will impart on today's topic. So throughout I've mentioned before, throughout the sessions, if you have any questions, you can include them in the chat box. But should you have more specific questions, you can always address them at Jamie's email address. So moving on to today's agenda, it's very simple. We will start with the introduction as to what is contract administrations. And then Jamie will be explaining his step-by-step guide, which relates to contracts, rights, and obligations, the strategy, and also implementation for the scope that falls within contract administration. So he will also be sharing lessons learned. I mean, like what to do and then what not to do, and then what actual circumstances, and then how you address it. And then eventually we will go to a Q&A session. If during the course of the session you really have a question that you wanted to ask, just pop in. I will try and read and then address it to Jamie, or else that towards the end we will have a full conversation on what your concerns in becoming executing contract administrations. So without further ado, I will pass on the session to Jamie, and then he can begin with his guides.
Okay, thank you very much, Lynn. So for the session today, we'll start off with an introduction. And just in terms of what we're going to discuss today, it's not a conclusive session, a detailed training, which we're offering, but is more of a highlight and summary level of the key portions of contract administration. So in view of today's developing world, I thought I'd have a little look on different AI portions and platforms to see what their view on definition of contract administration is. So on screen, you can see what Bing AI suggests as a definition of contract administration. So Bing says contract administration is the process of planning, preparing, organizing and executing a contract in the run-up to being signed. It's also involving the understanding of core objectives of business contract, outlining the scope of a project, and establishing what each party's obligations ought to be for the best results. The process of contract administration ends when the contract is agreed and everyone has signed it. It then goes on to say that once a contract is finalized, contract management begins. A contract administrator is responsible for ensuring both parties are happy with the contract they create together. Strangely, when I asked ChatGPT exactly the same question, ChatGPT provides quite a different definition. So ChatGPT focuses more on what Bing refers to as contract management, and it focuses on the post-execution. So it's saying that contract administration is essentially administering the contract throughout its life cycle. It's complying with the terms and conditions stipulated in the contract, and it's monitoring progress, managing changes, variations, administering payments, maintaining accurate records, and facilitating the successful execution and completion of the contract obligations. Effective contract administration is crucial in construction projects to ensure that the project is delivered on time, within budget, and in accordance with agreed upon specifications and quality standards. So my view actually is a little bit different. And I think that that's one issue with AI, that it will give quite a comprehensive viewpoint, as exampled by ChatGPT and Bing AI. However, it may not be definitively what you're looking for. So for me, the reality is that there's portions of both. Contract administration can be prior to the signing of the contract. However, the real contract administration fundamentally gets started after signing the contract. So when we're signing a contract with the contracting parties, what we're really doing is making sure that we've considered what is detailed within the contract, and we're agreeing to adhere to those obligations. That really is key. So if a party fails to adhere to those obligations, they can put their rights at risk under the contract and may even end up in default. So the process of contract administration for me is to perform your obligations and also to protect your rights. So it's the essence of a core role of contract administration.
So Jamie, before you continue on, so on this slide, you said that some portions of the contract administration commence prior to signing of a contract, and then fundamentally it starts after signing the contract. So how do you resolve the issue in having of different understanding between the current party or the current team that will be executing the contract with the teams that's negotiating the contracts. As you said here, so I would assume that prior to signing, it will be a different team, and then the one that's actually executing the contract would be a different team. So there might be a slight different understanding on the contract terms and conditions. So in your opinion, or how would you resolve the issues?
Okay, so first of all, on perhaps a difference of opinion between different teams of people. So ideally, that should be avoided in the first instance. So the contract is really there to properly detail what has been agreed. So if you have a scenario where perhaps a tendering team has a certain understanding of what the contract says, and a project team laterally has a different understanding of what the contract says, then there's a problem with the contract. It clearly has not represented in a very concise way exactly what the agreement of the parties has been, in order that there isn't this issue between two different teams in the same organization. So that's the first thing. So the contract needs to be clear. The second thing is to resolve those issues. Unfortunately, you would probably need to pursue discussions with the opposing party. And if they had the opinion of the pre-tender team and did not currently agree with the project team, it's going to lead to a dispute through the project and would need to be resolved in that dispute resolution process in accordance with the contract conditions. Okay, so hopefully that answers that. Just before we move off of definition, there's something that AI said that I just want to be clear with the participants in this session. So ChatGPT essentially said that it's to ensure the project is delivered on time, within budget, and with the agreed upon specifications and quality standards. So just pulling that apart, it's true that contract administration can ensure that the project is completed in alignment with the specifications and the quality standards. And it's also true that it can assist with time because of certain obligations and contract obligations related to programming, and the same with the budget. But it really does not ensure that at all. So just because you're administering the project properly, there will still be events that could occur that may lead to the budget being exceeded and the project not being delivered in accordance with the contract timeline. The importance, however, is that we're administering it to deal with these changes properly, rather than it being left to some form of dispute throughout the project. So let's move on to a step-by-step guide. So as Lynn said in the introduction, from my point of view, there are three major steps to adhere to when administering contracts. And the first step is the contract rights and obligations. The second one is to take the strategy from those contract rights and obligations, and then to implement that strategy. So three clear and concise steps. So on step one, the contract rights and obligations, what do I mean by that? So the first thing I always do when dealing with a contract admin role or a claims role is to fully understand what's in the contract. I actually want to be at a stage where when anyone in the project team has any query or clarification on the contract, that they come to me and they ask, hey, Jamie, what's the scenario with this? There's this issue on site. How does that fit into the contract? The project management team have asked for this document. Is that what we should be providing in accordance with the contract? And the ideal scenario is that the contract administrator is the oracle of that information. They're the oracle of the contract. So it's not possible to do your job properly unless you really understand fully what the contract says and what it does. In many of the contracts that the participants on the call will be dealing with, you'll have a standard form of contract, and then you have substantial amendments. And I won't go into the details of whether that is right or wrong, but what I would say is you need clarity as a contract administrator on what those conditions are. So what I'd always recommend is that you recreate the conditions of contract as a tracked document. Previously, I had an example on a project where the core contract conditions, unamended, so standard form, I believe they were around about 55 pages of contract conditions, and the amendments to those contract conditions were actually 57 pages. So we had more text amending the contract than we did in the original contract. And if you are trying to understand how to deal with that, it can be very confusing. I've given an example down the bottom, and I'll zoom in on that for you. So this is an example of a contract which I was working with a few years ago. And literally, this is the extract related to 𝗪𝗪𝗲𝗿. So it's inserting in the third line, after a specific wording, a specific phrase. And then these amendments keep on going, inserting a few words here, inserting a few words there. Now, if you're trying to read that as a contracts administrator, it can be quite complex and quite difficult to fully understand where the word goes and exactly what word goes where and what's been deleted. So I would always create this tracked version of those conditions of contract so that you do have that complete clarity on what the conditions say. So beyond doing that preparatory work, what you want to do is you want to understand what's included, how does it function, and what are the key rights and obligations. So at the top of this slide, you can see our relatively standard rights on obligations schedule. These are just the headings. But what you really want to do is to go through the contract and detail out the key points. So this example here, you can see it has the reference document. So in some cases, you might have different portions of the contract documents. So clearly you have the conditions of contract, but we also have specifications, we have sometimes scope of works, we have various different elements such as preambles, etc., etc. So what we would do is go through that those contract documents, providing the reference to those documents, a clear indication of the subject.
I can stop you for a while. Some of the comments are saying that you can't see the slide changing. Can anyone confirm that you can see the current slide, which is showing the contract rights and obligations and the table? Can you? All right, thank you. All right,
it's okay.
Yeah.
Okay. Yeah, so what I was saying there is, with regards to the subject, this element here, it's quite important that we make this searchable. So I always try and provide some consistency so that if you have an issue which comes through, it's easy to find that subject. And then we have the precise and key point that you're trying to make. So it's not about replicating the entire contract or the entire clauses. We're really pulling out from that contract document, from the conditions of contract or the related contract documents, what is the key point? What is the precise issue that we have? And then we are categorizing this into various categories. Sometimes that will be purely based on a right or an obligation, or in this scenario, we actually, for this particular client, we looked at risk, obligation, liability, and opportunity. So from those conditions, is there opportunity to enhance their position, either with time or financially? And then that promptly leads us on to the implication. So we're pulling out these key points, we're identifying which category is it, and what's the implication. Is it going to be financial? Is it going to be time? Or it could also be quality. And then we're inserting the severity. So clearly, when we go through, there might be some issues which are just to be considered. They might be important, but there might be some which are of high importance. There might be some which are critical, such as basically conditions precedent to entitlement for some other remedy. And also, very importantly, is the primary responsibility. So no point in going through the contract, pulling out all of these key points and the categories, the implication, the severity, but there's no allocation of responsibility. So you've got this great document, which is sitting in your file. You know all of the information about the contract, how it operates, but no one's responsible for the issues that you've pulled out. So that's very important to have. And then lastly, what's the comment or the action? And that may well be, the comment may simply be to be noted by the project team. The action might be to incorporate that into a project delivery plan or a quality plan or specific procedures for payment applications, etc. On the screen at the moment, you can see different examples that I've just pulled out of previous projects and previous rights and obligations schedules. So the one at the top, just as an example, so it referenced item number 35 and a specific clause of 3.5, and it's detailing out what has to happen in order for the employer to determine a specific decision, to provide fair determination. So in there it has details of what has to be done and the timeline when that has to be done. And clearly it then needs to be considered who is going to be responsible for that and what's the output of that. And essentially, from my analysis of this particular issue, the key point is that if there's no agreement on that determination, the obligation is for the contractor to raise a notice within 14 days to dispute the matter. So that is the key action, that ensure notice of disagreement to determinations are issued within 14-day period if such disagreement exists. So some other examples of this are below with another project, whereby going through those clauses of the contract, it's important, again, to just pull out those key elements. So just as an example, compliance with laws, specifically in this clause, it's actually saying there's responsibility for utility relocations. This was actually done during tender stage. So the identification of these issues were important for the tendering party. So identify liability and incorporate as appropriate. So i.e. in the bidding party actually has to ensure that those utility relocations are included in the fees and the contract sum. And going through again, you're just trying to identify all of those precise or key points, identify the person with primary responsibility and what those comments or the actions are. If regards to 2.1, very strangely in this particular item, I think there was a draft LOA had been issued. So although this was during tender stage, it was in the final stage. I believe this was actually final, last and final price. It was after a number of negotiations, and there had been receipt of a letter of award. And there's a conflict between what the draft of the letter of award was and what the contract actually says. So again, good to pick up on those at the very start of the project so that those can be raised in accordance with what the contract says for discrepancies between the documents. And another one of particular note, again, it gives the opportunity for the contract administrator to see if the contract functions. So down on 3.6, in the project manager subclause, it actually says no authority to give instructions or override the authority of the engineer. So that actually was the project manager has no authority to give instructions or override the authority of the engineer. Latterly in this project, which was awarded to the contractor, there was problems because the project manager did give instructions and they didn't have any authority to do so. So really important that that's picked up and the project team are aware of that and can deal with that issue as it occurs.
GB,
Yeah.
Before you move on, can you move back a slide? So we have a question here. So, and I think it's relevant before you move on to the next topic. So the question is asking, this contract rights and obligation schedule, it appears a summary and highlights of all the contract terms, which helps you administer the contract optimally. So it gives, instead of going page by page inside the contract, it allows you to have to pick and then see like, okay, this is the relevant contract clause. So how can this schedule be implemented in the team itself instead of just being used as your own reference?
Yeah. So we will come on to that, but the point is very valid. This isn't to sit in a file and look good when you're sitting on some Saturday morning, no one's in the office, and you can flick through. This is supposed to be a functional document. So the advice which I'll go over as part of this presentation is the project team needs to be briefed on this document. And not only briefed, but there needs to be an understanding and agreement related to what this document says and the strategy which is going to be implemented throughout the project. So certainly not a document just for the file, a document to use and action throughout the project.
Okay.
So as part of these rights and obligations, feel free to do certain flowcharts. This is a specific extract from a former contract. But these are important for people to understand because in this particular scenario, there are certain clear steps to get from the tender process all the way through to the completion of the project and return of the performance security. So these types of things are very, very useful in providing assistance, not only for the contract administrator, but also for the project team, so they fully understand that. So beyond the rights and obligations schedule, and whether you use the schedule, whether you follow the schedule on screen, it doesn't matter too much the exact headings that you use. What is really important is what I said at the start, which is that the contract administrator fundamentally understands the conditions of the contract, and they understand how it operates, how it all goes together. So the process of getting to that stage for the contract administrator might be done in a slightly different way. It might be looked at differently, but the end result must be the same, that the contract administrator is fully informed as to the contents and operation of the contract. So step 2, strategy. So now we have a clear understanding of the contract. Well, what do we do with it? As we said, do we put it in a file and never look at it again? No, we need to develop and formulate the strategy and really make sure that you adhere to those obligations in order to achieve your rights under that contract. And for me, this should include the inner workings of what needs to be done. So high level, we're saying, okay, we need to raise a notice, we need to do this, we need to submit a performance bond. All of those need to go together into processes. And that might be part of a project delivery plan or a project execution plan. It may even form part of a QA plan or QC, and may even form part of a commercial management plan. However, there's got to be a plan. There's got to be that strategy to make sure you take those key points and put them into a strategy to deliver the project successfully. So I listed down a few items there which I think are important to discuss. So change management, document management, the program and progress reporting, payment application, claims process, and also submittals. So let's first of all look at change management. So from the contract, what constitutes change? The whole premise of a contract document is to detail out those agreements between the different parties. So we should be able to go to that contract and really understand what does constitute change and how are we going to deal with that change. So as an example, are there different types of variations? So it might be that in the clause of the contract, it might actually have a variation opportunity, which is just a request for a quote. It might not actually be a variation yet. It might be that there is a separate clause whereby it specifically instructs additional work. It might be that there is some clarification that there will be verbal instructions, but those verbal instructions will not be operable unless they are confirmed in writing. So all of these elements you need to consider and detail out your strategy, how you're actually going to incorporate those into the project delivery. So for example, if there's instruction response required and also a timeline, you need to detail that out in your strategy to make sure you adhere to those. And just as some examples, and throughout this short presentation today, you'll see I'm using lots of different forms of contract, and really just to show that there are, whilst different offers of the standard forms of contract, fundamentally they're very similar in nature and they're very similar in terms of how they function. So in terms of PALM 2006 with quantity, it actually provides an opportunity for the contractor to request under which contract clause the architect is empowered to issue a certain instruction. It also details out that if the contractor fails to comply with an EI, according to clause 2.4, what can actually happen. and the fact that the employer may proceed and pay someone else to perform those activities under the said instruction. But all of those types of items, which these are just two examples, these need to be built into your strategy for delivery of the change management on the project. If we talk about document management, we need to agree how documents are going to be stored. So are we going to use an electronic document system such as Aconex or others? And importantly, how will those be referred? So if we have a work breakdown structure, or we have a project where there is sectional completions, it would be sensible to structure your document management to align with those contractual obligations. So let's just say we have a project, let's just say it's an airport, and for that airport, there are different handover zones, and those handover zones being related to the operation of the airport and the incoming services, plant and equipment for the airport operator. So we would want to structure our document management system to align with that, so that when we actually have notices related to those zones or those levels or elements, that it's clearly identified. As an example, with the airport, perhaps there's a baggage handling area, and that has an early access date to allow the baggage handling equipment to come in. So really important, if we've got that contractual obligation, if in the program and the work breakdown structure that is detailed in the program as a milestone, it would be sensible that our document management is properly aligned with those. So it makes it very easy and very clear that when we're issuing letters, when we're having specific meetings related to that area or design issues, RFIs, that it's all categorized to align with the contract delivery strategy to make sure that we can clearly rely on those documents and records later on. Now, related to that document management is the submittals. So whilst we are performing the contract, it's important for the contract administrator to have a strategy on what documents they will review before they're issued. So unfortunately, from time to time, we may have a very strong commercial and contractual team on a project, but actually on the project delivery side with the site management team, perhaps the person who is writing the minutes of meetings or is actually responsible for the site management of a certain aspect of the project, they might be fantastic at doing their day-to-day site management, project management of that element of the project. However, they may not have full consideration of those contract requirements. So for our contract administration, we would always be keen to make sure that we review those types of minutes, and that you as a contract administrator review these key documents, because these documents will either assist you or will be a nail in your coffin later on in a dispute resolution process. So really important that there is an alignment of the project team, that those documents are reviewed and that they're heading in the correct aligned project team direction. So that's part of that document management process for the contract administrator. What documents should be seen? What documents should be approved by the contract administrator before going out? Very similar with letters. Are all of the participants in the project able to issue letters, or is it the authorized representative of the company, which clearly should be the latter? even from the viewpoint of in terms of modern communication, should we be using WhatsApp? And in those massive WhatsApp groups, which I'm sure everyone is a member of multiple groups, like what should be the discussion points in there from a contract administration point of view? Clearly, when we're talking about access, when we're talking about instructions, maybe that is initially discussed in a group with the project team and the client. However, for sure, that's got to make its way back into a proper correspondence document, which is going to hold its time as proper evidence of what has occurred and is really going to be seen by the contract as its correct instruction according with the contract conditions. With the program and progress reporting, again, the key inclusions of the program. So what do we need to include in that program from a contractual perspective? So the contract administrator should ideally be giving the planner, for the program, we need to have these handover dates detailed as milestones. We want to have an element of provisional sums, whereby we can actually detail what provisional sums are in the contract and when those instructions need to be given prior to it causing a delay event. In terms of the work breakdown structure, again, similar to those handover and completion dates, what needs to be in the program. So if we allow the planner to go ahead, might be a fantastic program, but without that input of the contracts administrator and that strategy on the program, it may be that we lose opportunities later because we don't have those elements in the program. We don't have a provisional sum date. So there's debate later, when should the provisional sum have been instructed? We don't have a handover date detailed. So there's debate about, well, when should that have been handed over to you? And similar with the completion obligations as well. Progress reporting, very important as well from the contract administrator as to what needs to be included. Does it have to have a progress updated program? Does it have to have labour and plant information? And also there may be other detailed data required from the contract. So just as an example, I pulled out some contract clauses. On the screen we have PAM 2018 without quantities, and this just provides an example of the detail that is set out in a contract for the contract administrator to read, understand, allocate a task or a responsibility to someone else. So here we have within 21 days from the receipt of a letter of award, the works program needs to be submitted. In this case, it's even given an exact number of copies, and it will go into further detail in other occasions. With PWD, not so much, fairly simple, but within 14 days, and in this case, in such form and details as determined by the SO. And then as an example from FIDIC, the Red Books, it's providing a period of 28 days. And it does go on to detail that the program has got to include the order in which the contractor intends to carry out the works, stages, sequencing, and also supporting report, which in essence describes the delivery of the project. Moving on to the payment process, also very important what the prerequisite conditions to payment are. So in some cases, those will be performance bond, insurances. So it's the contract administrator's job to make sure they understand that and that they raise this issue prior to payment. No good, the QS on the project does a fantastic submission for application, and it comes back, we're not going to pay this because you haven't submitted your performance bond on time. Or the prerequisite is that you had to submit your insurances within 7 days of the letter of award. Like, all of that should be resolved promptly to make sure that you don't have these issues. With the 𝗪𝗿 Yellow Book, we have an excerpt from 14.3, which is the application for interim payment, and it specifically details out the contractor shall submit a statement to the engineer. It will be in a form acceptable to the engineer, must be submitted in one paper original plus electronic copy. And then importantly, item C, show in detail the amount the contractor is entitled to, together with relevant report on progress in accordance with clause 4.2. From this, 3 items doesn't seem too onerous to deal with. But then when we refer to 4.20, actually, we need to include quite a lot. We need to include, as part of that progress report, which is to be submitted, we need to include all of these items A through G, and those may be very time consuming to prepare. So it's not about waiting until this is a problem. It's actually about putting the strategy into the project delivery plan so that you don't have a problem. And that, in my view, is the paramount importance of the contract administrator in dealing with these issues. On screen and moving to claims and on to dispute resolution. Just on screen at the moment, we have it's actually 2 different flowcharts. We have one which is on the left-hand side of the claims procedure, and we have the middle and the right, which is the dispute resolution procedure in this particular contract. Now, what is important is this isn't actually an extract from a contract. This is an analysis of what the contract conditions actually say. So if we zoom in a little bit further, we've went through, in this case, this particular contract, and we've done a flowchart to say, okay, clause 19.1.1 says this. This is what we got to do. And what's that process? So we got to do an impact assessment within 28 days. Then the engineers to give their evaluation. Then we have to give a notice of dissatisfaction if that's not if it's not agreed. If it's a continuing event, this is what's happened. There's a time bar if we fail to give notice, if we fail to give impact assessment, etc., etc. So all of that needs to be understood. And if we say to the project team, in terms of the project manager, or if we say to the site manager, it's in the contract, go read the contract. That's not, I think, a productive or a fantastic solution for a project team. Actually, by the contract administrator properly doing their job, they can pull all of these elements out and properly explain that process to the project team. In terms of specific examples, which leads on to another topic related to this, is we have these issues of notice provisions and very detailed timelines upon which certain actions need to be taken. So this example is from PAM 2018 with quantities, and the example is providing the timeline for when the notice needs to be provided, and it goes on to specify that this shall be a condition precedent to an entitlement to extension of time. And 23.1b goes on to detail out the particulars and when those need to be submitted. So really important when we have things like conditions precedent, that we need to ensure that we fully comply. So not to diverge too much off topic, but highly related to that contract administration process is some of you may be wondering, what is a notice? So in any contracts that we'll see, the example on screen, give a written notice. So ideally, at the start of the project, in your strategy, you are defining what a notice is going to be at the start. You're actually agreeing formats with the other contracting party so that there's no doubt in anyone's mind what a notice is. If you're using a letter format, you should again very clearly refer to it as a notice and make sure that the relevant subclause under which you're raising that notice is clear. And the benefits of that for the project team is everyone knows the rules of engagement from the start. And if you know the rules, you can play by the rules. If you don't know the rules or ignore them, you're going to get yourself into some problems. A typical example on the right-hand side, actually from a contract, new engineering and construction contract. This is an early warning notice. So this contract actually requires you to raise an early warning to get the matter resolved. So highly recommend, even if the contract does not suggest this, as a competent and really well-performing contractor and contracts administrator, these types of early warning notices are fantastic because it gets the issue out, it deals with the issue very promptly, and it deals with, for instance, what your proposed action or remedy is, and also your response. Clearly, it needs to fit in with the conditions of the contract in terms of it can't contradict, but we'd highly recommend for those on the call doing some of that type of approach, trying to be very proactive. So once we've got all of that rights and obligations understood, what's in the contract, and we then have our strategy, what do we do next? Well, we need to advise the rest of the project team. We need to explain very clearly those key rights and obligations, and we should ensure that actions are agreed or amended to properly deal with matters. So I would recommend, and we always do this, is have a presentation session at the start of a project. The contract administrator should go through what those rights and obligations were and their intended process to make sure that you are adhering to those rights and adhering to your obligations and protecting your rights. That is really fundamental. And then don't just put the document back in a file and never to be talked about again, but it does need regular discussion. And you also need to have refresher sessions. So for instance, if there's a new project team member, a new project manager, commercial manager, whatever the case may be, it's worthwhile doing those refresher sessions. It's worthwhile revisiting the presentation and making sure that that project team that is now operating the project fully buys into your rights and obligations, fully buys into the strategy, and properly implements that strategy. And also review and reconsider when senior management has changed as well. So sometimes we have scenarios in the contracting realm where we have a project team and we also have an executive team in the HQ. Sometimes that team will change and the ideas and the strategy of that team may differ from the previous team. So important that you are again refreshing those key members of the senior management and making sure that there's an alignment on that thought process in terms of strategy and implementation. So with our lessons learned, as I said, it's not a long session today, It's just really a short highlight and summary, but some key lessons which I'd like you to take away from today is to know your contract inside out. Be the oracle of the contract. Be the person that for every meeting or for every issue that relates to the contract, the PD comes across and says to you, hey, you know that issue we're going through, how does that relate to the contract? What's your opinion? Be that special person that has read it inside out and protect your company. Only agree a contract which can function and can function properly. So unfortunately, there will be, in many cases, various amendments which are made to standard forms of contract. And without proper consideration, those amendments can actually lead to a non-functioning contract. So if you're involved at that contract stage, do make sure that it functions. Think about how those clauses and amendments interact with each other so that the overall contract functions properly. Have regular meetings on contract administration issues. So your role as a contract administrator is not, you're not an island. You need to be involved in the project team. And only when you're involved with that project team can you properly function as a contract administrator. So have those meetings, get the support and respect of the project team, and make things easy for the project team with clear and concise requirements, leading back to that strategy element. If you properly thought through all of those elements, the project team will support you and will respect the efforts which the contract administrator has went into. Utilize and adhere the notice requirements, including the timelines, and provide feedback to the executive and tendering team on issues to avoid in future contracts. Without that feedback, it won't get any better. Issues will continue to be repeated again and again. So very short, only less than 1 hour, but we do have some opportunity, a few moments for some questions. Maybe there's some questions in the chat, or if people would like to raise those questions now, happy to try and answer them.
Anyone have any question for Jamie? So I'll give you guys a minute to form your questions. In the meantime, I have a question for Jamie. So essentially today's topic revolves around a successful contract administration. So obviously you have to know your rights and obligations. So in the circumstances at the beginning of the project, between these two parties that have signed on the contracts, they are trying to put on an amicable situation for both parties as to prevent any animosity or like bad feelings and so on. So what they do is, if in the event there's a delay or something that's obstructing from the project for the project to progress, instead of notifying one or another contractually, they try and to reach out outside the contract terms, like you said, like maybe through WhatsApp or maybe just through emails. So in your opinion, would that be wise, or would you advise that you should establish that everything should be handled contractually from the very beginning, and then or it's a good strategy just to go with the flow, but assert some importance that contract is still of the importance? So what would be your advice and opinion on this?
Okay, so I think what you're describing, in my experience, happens quite a lot, where a contractor or an employer, because maybe starting the project, they don't want to be too contractual. And instead of raising the correct notices or the correct letters to detail out certain issues which are occurring, they tend to shy away from that and tend to discuss it and try and resolve things in an amicable way. And my viewpoint for sure is do try and resolve things in an amicable way. However, also follow the contract. That the contract is there to be adhered to literally protect your rights. And if you decide not to perform your obligations as stated in the contract, you are running the risk of losing some of those rights or even defaulting on the contract. So yeah, I would wholeheartedly agree you need to try and solve it by verbally discussing, but just record it as well. There's no problem in doing that. And highly recommend stakeholder management sessions whereby these things can be discussed in a very open way between the parties to try and make sure these things don't escalate to disputes. However, they should still be recorded during the progress of the project to make sure you don't lose your rights. Yeah.
All right, thank you. So so we have a question from 𝗪𝗲𝗂𝗁. I'm sorry if I pronounce your name incorrectly. So first of all, he said, thanks, Jamie, insightful overview. So Sashi would like to understand your view or thoughts on regarding level of competence requirement or knowledge on contract terms and conditions for project managers, especially in situation where there is no dedicated contract administrator in the team.
Okay. So is the question, should there be a certain level of competence? I'll answer that question, which I believe it is. So yeah, for sure there is. There should be, because if the project manager does not have that contracts administrator within their overall function, if they have that responsibility, they need to understand how the project, how the contract functions. They need to understand how they can properly, I'm going to repeat the same term again, but properly adhere to their obligations and protect their rights. They've got to. And whilst it may seem like it could be very confusing, could be very complex, there is fantastic resources out there to assist. Those resources might be from some sort of audiobook, some sort of online course, or even an entity to provide training. But as a PM who has that responsibility to look after that, you should know about how to administer that contract. Yeah.
Does that answer your question, Sashi? So
yeah,
if you have
that answers my question.
more details that you need to know, definitely you can email Jamie. So is there any questions anyone would like to ask? So if there's no questions, I think our BrainHuddle session has come to an end. I would say from today's topic, I would gather that eventually for a successful contract administration, the key would be communications, whereas because it doesn't matter whether you're the employer or the contractor, if you are unable to communicate with one another, you can have a contract that details out everything up to a very detailed out to a grain. But if nobody communicates it and put it into execution, then it would not matter. So I would like to thank you guys for joining us today, and thank you, Jamie, for the informative session. So just to let everyone know that PMCC organizes BrainHuddle sessions for free each month. So if you like to join our future sessions or events, be sure to follow us on all social medias. We are on LinkedIn and Instagram. And it's all listed in our chat box. If there's nothing else, we hope to see you again. So have a good lunch and goodbye, everyone. I'll see you guys again.
Thank you.
Thank you.
Bye.